For today's story, we talk about how much money you have to pay when you don't file the right reports at tax time. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content. And today's the day I earn a subscription. For today's story, we're talking about a brand new U.S. Supreme Court case. This is Bittner versus United States and deals with tax liability and reporting on the tax liability. Now, this guy had some money overseas, and the issue is the federal government thinks that he hasn't reported the money correctly. And so they think that he owes some money as some penalties. And the question is, how much penalties? The federal government calculated the penalties at $2.7 million. So a little bit of penalties for the non-payments or the misreported payments on the taxes. So does Bittner have to give the IRS $2.7 million in penalties? Let's read more. The Bank Secrecy Act and its implementing regulations require that U.S. persons with certain financial interests in foreign accounts file an annual report known as FBAR, Report of Foreign Bank and Financial Accounts. So the United States government has gotten wise to the idea of people having their Swiss bank accounts and Cayman Island bank accounts and so forth and so on, and said, okay, if you have these foreign bank accounts, you've got to tell us about them because as a US citizen, you owe us tax and we want to know about the money so that you can pay us the tax. You got to report your foreign bank accounts. So the Swiss may want to keep your bank account secret, but you got to tell us. The statute imposes a $10,000 penalty for non-willful violations of the law, even though you didn't try to deceive the government. If you misfiled your forms, it's a maximum of $10,000 fine. It's not that you tried to, it's not that you were deceiving us, it's not that you were trying to hide it. This is non-willful. You just screwed it up. So if you screwed it up, even if you didn't try to screw it up, you owe us $10,000 penalty or up to $10,000 penalty for a non-willful violation. If it's willful, we want more. But $10,000 for non-willful. These reports are designed to help the government trace funds that might be used for illicit purposes and identify underreported income that may be subject to taxation. The U.S. government wants its tax money. The petitioner, Bittner, is a dual citizen of Romania and the United States, learned of these obligations after he returned to the United States from Romania in 2011. He's living overseas in Romania, and when he comes back from Romania in 2011, federal government's like, you got any money? He subsequently submits the required reports covering 5 years. The government deemed these late filed reports deficient because the reports had not addressed all accounts to which Bittner either had signatory authority or qualifying interest. He didn't apparently reveal all the accounts, perhaps because he misunderstood, or at least we believe he misunderstood because these are, again, non-willful violations. He reported some of the accounts he owned, but not all the accounts to which he was supposed to report. Bittner then filed corrected reports, providing information for each of the accounts. 61 accounts in 2007, 51 accounts in 2008, 53 accounts in 2009, and 54 accounts in 2011. He had a lot of accounts. The government neither contested the accuracy of these new filings, nor suggested that the previous errors were willful. We don't think that you were we're not going to at least say that you did. We're not saying that you did this willfully. You didn't report all the accounts you were obligated to. And he's now filing corrected reports, and we think honest oopsies. But despite the fact of honest oopsies, because the government took the view, the non-willful penalties apply to each account not accurately or timely reported. And because of these 5 late filed annual reports involved 272 accounts, the government calculated the penalty at $2.7 million. So again, it's not that we think that you're deceiving us. You made an oopsies, but you made an oopsies 272 times. So that's $10,000 per time. So give us $2.7 million. Bittner challenges the penalty, arguing that the law authorizes a maximum penalty for non willful violations at $10,000 per report, not per account. The Fifth Circuit said, give us $2.7 million. The US Supreme Court says the $10,000 maximum penalty is per report, not per account. So, how about $50,000 instead of $2.7 million would be the bottom line on that one. You filed 5 wrong reports. So, it's not per account, it's per report. And so you owe $50,000 in penalties instead of $2.7 million in penalties. So, $2.7 million break. So, good for Bittner. I would also like to take note, just for the sake of pointing out what I hope is obvious, that yes, the IRS does lose cases. The IRS does lose cases. You can win against the IRS. It is one of those things that brings hope to my heart, right? Even the IRS does lose cases in its own courts. The IRS just lost a case. The IRS just lost $2.7 million. So I'm proud to be an American. It's a good time. The court begins with the terms of the most immediately relevant statutory provision. That's a good place to start, which delineates an individual duties under the relevant law and a different section which outlines the penalties that follow from failing to discharge. The relevant law provides the Secretary of the Treasury shall require certain persons to keep records, file reports, or keep records and file reports when they make transactions or maintain a relationship with a foreign financial agency, think bank. Although not necessarily, because again, Congress isn't that dumb. The statute states that reports shall contain information about the identity and address of participants in transactions or relationships, the legal capacity to which a participant is acting, and the identity of the real parties in interest, along with descriptions of transactions. The relevant law does not speak of accounts or their number, but rather the legal duty to file reports, which must include various kinds of information about foreign transactions or relationships. Violations of the law's reporting obligation is binary. One files a report in a way and to the extent the secretary prescribes, or does not. Multiple willful errors may establish a violation of the law, but even a single mistake, willful or not, constitutes a violation. So if you willfully violate it, that's bad. But if you non-willfully violate it, that's also bad. The only distinction the law draws between a report containing a single mistake and one containing multiple mistakes concerns the appropriate penalty. The relevant law authorizes the secretary to impose a civil penalty of up to $10,000 for any violation of the law. The non-willful penalty payments does not speak in terms of accounts, but rather pegs the quantity of non-willful penalties to the quantity of violations. The relevant law provides that a violation occurs when an individual fails to report consistent with the statute commands. Multiple deficient reports may yield multiple $10,000 penalties, and even a seemingly sufficient simple deficiency in a single report may expose an individual to $10,000. So even once. But penalties for non-willful violations accrue per report, not per account. So the secretary has a right to charge up to $10,000 for any violation, even a small violation, if the secretary wants to. $10,000. That's a lot of penalty. Apparently, Bittner over here, though, not as much with the 272 accounts. So it seems like he's doing okay financially. His joint Romanian citizen, U.S. citizen life seems like he's doing okay financially. $10,000 for even one failure to report these foreign accounts. But the issue is the report, not the accounts. So, yeah. To be sure, for certain cases that involve willful violation, the statute does tailor penalties to accounts. The relevant law specifies additional subclasses of willful violations that include failure to report the existence of an account or identifying information required to provide with respect to the account. In such a case, the secretary may impose a maximum penalty of either $100,000 or 50% of the balance in the account at the time of the violation, whichever is greater. Ouch. So if you are willfully defying the law, how about $100,000 or 50% of the money in the account. Again, if you have foreign bank accounts, you might want to make sure that you're reporting that information correctly because, yeah. And if they find that you're doing it willfully, how about just give us half the money? This is the Joker. What do you want? The government maintains that because Congress expressly authorized per account penalties for some willful violations, the court should infer that they meant to do that for non-willful violations. That doesn't make sense. That doesn't really make sense. Congress obviously knows, because they just did it just now. They obviously know how to say per account when they want to. So if they didn't say per account, then perhaps they meant something else. But the government's interpretation defies a traditional rule of statutory construction. When Congress includes particular language in one section of a statute and omits it from its neighbor, the court normally understands the difference in language to convey a difference in meaning. To express the one is to exclude the other. Yeah. So if Congress says something in one section, they express something in one section, then they're excluding the other thing, because Congress obviously knows how to write something when they want it to be true. And so if they express it and then don't, it's probably because they don't want that thing. These are standard rules of statutory construction, not that hard. Here, the statute twice provides evidence that Congress knows how to tie sanctions to an account level when it wants to. Congress said in one section and then a different section that various penalties for willful violations may be measured per account. And Congress said in some other section that a person may invoke reasonable cause exception only on showing of a per account accuracy. But Congress did not say non-willful per account. So Congress, when they write words, they mean those words, and then they don't mean it in other sections. So Congress obviously wanted per account. Well, they obviously didn't, because when they wanted it, they said it. They know how to say it. They just said it just now. They know how to say it. And it also doesn't defy reason at all. Your report is wrong. Pay a penalty. You're trying to cheat us. Pay us a bigger penalty. It's pretty logical. So it doesn't even defy logic. The court finds a number of additional contextual clues that cut against the government's theory. First, the government has repeatedly issued guidance to the public in various warnings, fact sheets, and instructions that seem to tell the public that failure to file the report represents a single violation exposing non-willful violator. So the agencies agree. While the government's guidance do not control the court's analysis, courts may consider the inconsistency as a basis of interpretation. Second, the drafting history of non-willful penalties provisions undermines the theory. In 1970, the penalties included only willful violations. In 1986, Congress authorized penalty on per account basis for certain willful violations. When Congress amended the law again in 2004 for non-willful violations, they could have, but did not, use the similar language from 1986 to extend it to the non-willful. Originally, they said penalties for willful. Then they said, how about per account penalties for willful? And then they said, how about the non-willful? So Congress obviously knows how to amend the law to say per account when they want to. Yeah, not so much. Still, other features from the relevant law and the regulatory scheme suggest the law aims to provide the government with a report sufficient to tip it to the need to further investigate, not to ensure presentation of every deal or maximize revenue for every mistake. Congress declared the law's purpose is to require certain reports or records that may assist the government in providing investigations. Now, when Congress explicitly in the law provides purpose, which they sometimes do, then it's perfectly proper for an originalist to consider it, because Congress is the one passing it. If Congress says our purpose and intent is to do a whole bunch of things, then great. Congress passed the law. And then to the extent that the statute is ambiguous, then you can absolutely, as originalists, go to the purpose as being informative. Not necessarily dispositive, because there might be other factors, but if you want to know what's Congress's intent and they tell you, here's our intent, that's pretty good. Absent is any indication Congress sought to maximize penalties for every non-willful mistake. The Secretary's regulations implementing the law require individuals with fewer than 25 accounts provide details about each account, while individuals like Bittner with 25 or more accounts do not need to list every account. unless the secretary wants more detailed information. So apparently, for whatever reason, if 25 accounts or less, tell us about every account. If more than 25 accounts, you can just tell us collectively. That's fine. I don't know how that really makes any sense at all. Like, why would you want individualized accounts for less than 25, but not more than 25? If anything, you would think it would be the other way around, because maybe it's just like too inconvenient for people with only a few accounts to really keep track of them. But if you have a lot of accounts, then it shows that you have the ability to keep track of them. So I'm not really sure why the regulations are written that way or how that makes any sense. But when did I have to understand why things made sense just to understand that's the law? Congress, or apparently the relevant regulations say if you have more than 25 accounts, then just generally tell us vaguely what it is. That's fine. Okay. Finally, the government's per account penalty reading invites anomalies. For example, subjecting willful violators to lower penalties than non willful violators. Yeah, I guess that's possible. Avoided by reading the non willful penalties to apply to a per report basis. The government's reply that per report interpretation risks the anomaly. The secretary could formulate reporting requirements to require a separate report for each account, and that way effectively achieve the per account penalty. What this proves is unclear, lol, as the secretary's discretion to require more or even fewer reports is not the issue, and in any event does not answer whether the secretary may impose it on a per report or per account basis. The federal government's like, this doesn't make any sense because the secretary could just require a report for every account. And the Supreme Court's like, maybe, I don't know. I'm not here to decide that right now. You probably could require a report for every single account. Best read, the law treats the failure to file a legal complaint as one carrying a maximum penalty for $10,000 per report, issued by Judge Gorsuch in an apparently 5-4 decision with a perhaps strange split. Gorsuch issues the opinion of the court in which Jackson, Roberts, Alito, and Kavanaugh join. Barrett, Thomas, Sotomayor, and Kagan dissent. So a perhaps non-traditional 5-4, but that is the respective vote of the court. And of course, I'm a Justice Gorsuch fanboy, so all things being equal, I'm gonna back my boy. So that was exciting. Very interesting stuff. Justice Gorsuch and I have certainly disagreed at times, but that sounds about right. So I found this to be exciting, and I hope you did too.